Hello, my name is Phil Seelig. I'm an attorney and senior partner at the Seelig Law Group. Today, we will be going over what happens at a Social Security disability hearing. When seeking disability benefits from the Social Security Administration, you may have to appear at a formal hearing. To determine your entitlement, a federal administrative law judge will adjudicate your claim. If your application is denied at an early stage, you may appeal by requesting a hearing. At that hearing, there is no opposing counsel. Instead, you will be questioned by the judge. Routinely, the Social Security Administration employs medical and vocational experts to testify at your hearing. You or your attorney will be given the opportunity to cross-examine those witnesses. Your hearing will be recorded. The judge will make an opening statement, and then witnesses will be sworn in. Typically, the proceedings will start with your testimony. The judge will ask a series of basic questions covering the following areas. First, your date of birth, address, living arrangements, and the highest level of education you've obtained. Second, your work history for the 15 years prior to your alleged onset of disability and the medical record which supports your claim. And third, what activities you're able and unable to engage in. The judge may aggressively test you on these areas, and this grilling may take anywhere from a few minutes to half an hour. After the judge questions you, your attorney will be given an opportunity to allow you to testify further, bolstering or rehabilitating your earlier responses. On one occasion, my client answered the judge saying that she went swimming 3 times a week. The judge took that testimony as evidence of her physical fitness. When I was permitted to follow up, I was able to clarify that by swimming, my client only meant she followed her doctor-prescribed aquatherapy, not laps across the pool. We ended up winning her case. Okay, back to the hearing process. Once your testimony is concluded, their medical expert testifies. She is asked whether you meet specific guidelines establishing disability. The medical expert may discuss how your impairments could otherwise preclude you from working. If the doctor instead asserts you to be capable, your attorney, through cross-examination, can now refute those findings. Next, the vocational expert takes the stand. He will testify as to how your limitations may prevent you from or prepare you for work. His testimony is also subject to cross-examination. The judge may make an immediate ruling even before the end of your proceedings, informing you that you've won. More typically, you'll be mailed a decision in a couple of months. In the event that this judge's ruling is partially favorable or unfavorable, you have the right to appeal that outcome. Because of the important difference your monthly benefits make during your life, it is sensible to acquire experienced legal representation. The Seelig Law Group can represent you for Social Security disability insurance in all 50 of the United States and in Puerto Rico. To find out if you qualify, call Seelig Law. Thank you for joining us for this installment of Law Matters. If you've heard anything that you would like to learn more about, or more importantly, you have a legal matter that you're ready to have an experienced and winning legal team help you with, please call us at the number on your screen, and an attorney will contact you by the next business day or sooner. Remember, when winning matters most, call the Seelig Law Group.
The Law Matters video series is provided as a public resource by the Seelig Law Group and is not legal advice, nor does it create any attorney-client relationship between the viewer and Seelig Law Offices, LLC. Always consult a licensed attorney authorized to practice in your jurisdiction regarding any of your legal matters. Remember, when winning matters most, call the Seelig Law Group